Hello, my name is Robert Lenz. I'm a law librarian and instructor at the University of Colorado Law School in Boulder, Colorado. In the next few minutes, I'm going to review with you a method to planning your legal research. We'll discuss how to parse a legal problem to identify key facts and issues, and then how to navigate all the various legal resources to find the authority to answer the legal issues. Let's begin. Fundamentally, let's recall that legal research is the process in which we find all the legal authority to resolve a legal problem. That is fundamentally what legal research is all about. In doing so, there are really three basic steps in the research process. The first step is planning our research. It is in the plan which we determine what authority it is that we'll need to find, and we'll determine in what publications we'll need to find that authority. This plan may be written, or it just may be something you think of before you begin your research and maybe jot down even or not. The second step is to create a research log. It's in a research log where you track what resources you looked at and when you looked at those resources. You also track what search terms you used when you searched at those resources, and you'll determine what value those resources had to your overall research. In other words, you're tracking what you found. And the third part of the research process is where you share the results of your research with somebody. This may be a written memo or a letter. It may be a conversation you have with a client or with a senior attorney. But in essence, you're telling this other party what it is you found, what the law is in this area. And in part, your plan will depend on what this research product will look like. But we'll get to that in a few minutes. In this video, of course, we're talking about a research plan and how to develop one, so let's start on that. There are two parts to developing a research plan. There's the problem analysis part, and then there's the research strategy part. In the problem analysis part, our goal is to understand the problem that was given to us. Typically, we will get a legal problem either as something that's written and given to us, or you may collect the facts and issues by talking to an attorney, or you may collect that information by interviewing your client. Regardless of how we get the problem, our methods here are really the same. Our goals are the same. We want to understand what the key facts are to the problem. We want to identify the issues that are involved. We want to identify the jurisdiction or jurisdictions. We want to have an understanding when the events took place. And we want to be able to answer what area of law or what areas of law does the problem involve. And this last question is important because we'll want to determine if we need to end up in the statutes or cases or regulations to finally answer the problem. There are various methods that have been developed to help us parse our problem. The one method that I like the best is called the journalism method, also sometimes known as the interrogative pronoun method. It is so called the interrogative pronoun method because it uses the interrogative pronouns of what, who, where, when, and why to help us understand what's going on in the problem. For what we're trying to ask ourselves is what are the events that occurred, what are the things in the problem, and really what's the problem that we're trying to solve, what was the problem that arose, and what's the legal problem that we're trying to solve. Who refers to the parties or persons or entities in the problem. If there's litigation pending, that would certainly be parties. But if they're persons or entities, the entities could be corporations, they could be government entities, whoever it is. And we also want to know what the relationships are between these persons, and particularly what the legal relationships are. Where did these events take place? This will help us in part to determine what our jurisdiction should be. Sometimes our jurisdiction may be a federal jurisdiction, and the events don't necessarily indicate that, but we have to remember to think about federal jurisdiction as well. When, at what time of day did the events take place? That'll help us get an understanding for the context of the problem, but also the date in which the events took place. Did it take place in the past? Is it something currently going on? Is it something that we're planning for in the future? We're particularly interested if the events took place in the past because we'll want to use those statutes or those regulations in effect at the time of the event. And finally, why? What is it that the parties want? What is it that that the parties are seeking, or what kind of legal solution? Are they looking for monetary damages? Are they looking for an injunction? Why does this legal problem even exist? After we do this analysis, we can then develop a list of search terms and search phrases that we will then use to research the print and online resources that we'll consult. At the end of the problem analysis phase, what we'll want to do is write down the answers to these various questions in a problem analysis part of our research plan document. I use Microsoft Word to collect this information, and on the slide you'll see an outline of the problem analysis part, with 1 being factual analysis, 2 being issues, 3 jurisdictions, 4 areas of law, and 5 the keywords. But you could use Microsoft Excel, you could use a Mind Manager software, you could even use OneNote or Evernote. Whatever it is that you're most comfortable doing. Anyway, we write it down, therefore we can track it. Okay, moving to part 2 of our research plan is the research strategy. And the goal of the research strategy is to determine which legal resources will enable us to find all of the controlling authority to answer the legal issues of our problem. How do we do this? Well, we develop a step-by-step strategy listing each resource that we need to consult, the search terms we'll need to use in those resources, and the order in which we'll consult those resources. So what we're really trying to do is consider what our primary and secondary resources are, whether they be the codes or the case reporters, legal encyclopedias, or practice treatises, whatever it is. We want to determine which one of those we'll want to look at and the order in which we want to look at those, so we're ultimately led to the controlling primary authority that answers our legal problem. So we're thinking about the type of resource and or the title of a resource. You might consider starting in a code, or you might consider starting in the Colorado Revised Statutes if that makes sense for your first step. And then we list each of those resources. There are some considerations that we'll undergo when we're developing our research strategy. One is, what is my starting point? Was there a citation that was given to us as part of our problem? Do we have a case or the name of an act? Or do we just have some keywords? A second consideration is what we already know about this area of law. Is this an area of law in which you're very familiar? You're already familiar with the terms of arts used, the key cases and key statutes? Or is this something that you don't know as much about and that you need to really kind of get up to speed and educate yourself about this area of law? Another consideration is, how thorough does the answer be? Sometimes the parties wants a quick answer and a quick overview. That will determine how thoroughly and what resources you look at as you develop your research plan. An important consideration is the amount of time and money that you have to do this research. That also will lead to this next consideration, which is, what resources do I have access to or maybe can afford to use? Sometimes if the time and money is limited, that may mean that you can't use an expensive subscription resource like a Lexis or a Westlaw, but rather you might use the free resources that are available on the internet. And then lastly, we should ask ourselves, if someone has already done the research for us, perhaps the answer exists in a brief bank or memo bank at your firm, or you can consult an American Law Reports annotation, or even a compiled legislative history where they'll have collected the information for you and give you a leg up on your research. So, strategies. Which strategy should you use? Generally, the advice is you start with secondary authority and then you move to primary authority. This is particularly true for researchers in newer areas of law. The secondary authority provides the context and the terms and the understanding that help you find that primary authority efficiently. However, if you already have that context, you've already educated yourself about that area of law, then you might start right with a primary authority. And always remember, use the entry points that are provided. If you have a citation, You may really want to start in an annotated code and then use the case annotations to find cases and extend your research that way. If you have a case as a starting point, you might want to look up the case and use the headnotes in the case to find other related cases and use a digest further to expand your research. You might want to start in a practice treatise, particularly if the answer is going to be quick or you need to find things like forms. And then from the treatise, you can then go find primary authority. You can even start in Google. Google might give you good background, give you some leads for primary authority, and help you further your research that way. All sorts of ways to do it. The strategy you choose is the one that makes sense for you, given your understanding of the problem and the information given to you in the problem. So once we've developed a research strategy, what we want to do is write that research strategy down into our research plan. You can create a research strategy part of your plan, as you see on my slide, where in step 1 I'm going to start with for this fictitious problem, I'll start with the Colorado Practice Series in print. I'll use a search term, term A, and I'll look in the index for that term to find where it exists in the Colorado Practice Series. In step 2, I may go to AmJur and use search terms B and C in the index. If AmJur is or is not helpful, I might go to Corpus Juris Secundum, another legal encyclopedia on Westlaw, and use that search phrase, term A, within the same paragraph of term B. I might then go to Colorado Revised Statutes on Westlaw and use a search term, or I might use the online table of contents to find where I'm going. And then I can use the case annotations as step 5. And if there are no cases or I need to find additional cases, I might go to the Colorado Cases database, use certain search terms. And then finally, I'll update my research. Every search strategy should include updating your research. Okay, and that's it. At this point, you begin your research and you use your research strategy as the foundation for your research log. In fact, the research log, in some ways, is an annotated research strategy. And remember a couple things about the research plan. It doesn't have to be perfect. It's a good guess at what the legal problem involves and what resources are available to help you solve it. And as you begin your research, you may find that the research takes you away from your actual plan. That's okay. Just go ahead and capture what your actual research is in the research log. And we'll talk about the research log in another video. Thank you. Please let me know if you have any questions.